If you'd like to reserve some time for rebuttal, let us know. And are you familiar with our light system, our warning system?
Yes, Your Honor.
Okay. You know what happens when yellow is on and then red.
Yes, Your Honor.
You may proceed, counsel.
Thank you, Your Honor. May it please the court. My name's Christian Van Riper. I'm the attorney for the appellant, Julius Kadlecz. That was actually a perfect pronunciation of his name. And basically, I'd just like to start, since time is limited here, by getting directly into what I think is probably the issue why this case may have been set for oral argument, which is, given that Florida statute 827.071.5, which is the criminal statute prohibiting possession of child pornography, requires not only that a defendant be proven to have intended to possess the subject material, but it also has to be proven that he knew the nature of the material. Given that that's the fact, is it possible to convict a defendant of that charge when the state openly concedes during trial that they couldn't even prove that the defendant viewed 2 of the 3 files which are subject of the prosecution? This case involves a situation where the defendant was charged by information and Second Amendment information with 3 counts of possession of child pornography. The defendant was convicted of all 3 counts. On one of the counts, the defendant admitted during an interview with police before his arrest, that he had viewed a file. But on 2 of the counts, there was no such evidence. There was no admission. In fact, he denied ever having viewed the files. And the detective admits during the prosecution of the case that although there was no evidence that these files were viewed, it's still possible that he viewed them, but no record of the viewing was ever found.
He can be convicted if he knowingly downloaded child pornography, even if if there's no evidence that he actually viewed it.
The argument here is that the statute requires, and there's a case on point with that, Schmidt v. State, which that it requires, and it actually describes it as like 2 intent requirements with this statute, which is 1, which is what I said, that he intended to possess the illicit material, and 2, that he knew that the material contained subject matter of an illicit nature, i.e. The material contained pornographic images of people under the...
Are you arguing that he wouldn't know unless he actually viewed, that even if the title is descriptive and he's told that this is what it is, that until he's actually verified that you can't satisfy the statute?
I believe that's the case, Your Honor, but in this case,
Do you have any case support for that?
And I haven't found a case on point, and one would think there would be, given the fact that it must be somewhat common of an instance for police to try and investigate a charge like this and not be able to actually prove that a person viewed what was on their computer. And yet I've found no case law, and I don't think the state cited any either, with regard to this specific issue. And I'm just, my argument is from a common sense perspective and based on the nature of the statute, based on the language of the statute rather, and based on the Schmidt case, which actually makes it a point to say that, look, there's 2 requirements here. It's not just that the state has to prove that he knew he possessed the material. They also have to prove the other point, which is that he knew what the material was. And I don't see how the state can be deemed to have proven that beyond a reasonable doubt when they openly admit that he didn't even, they have no evidence to show that he ever saw the material.
Since you refer to the language of the statute, isn't it reasonable to assume that if the legislature felt it necessary to have viewed the material, they could have simply written a statute to say that, requiring the state to prove that he viewed the material as opposed to knowing that the material exists on his computer?
Well, I think that the legislature could write a variance of things in the statutes that they write, but I also think that one could argue that they could, by not requiring that second level of intent in this charge, make it so that they wouldn't have to prove that a person viewed it. You know, they're asking, the state in this case is asking for you to assume that he probably viewed it, but we don't have any evidence to show that he did. So if the legislature, they could take that requirement out of the statute if they felt the need.
But the crime which the legislature is attempting to punish is the existence of this material being forwarded from person A to person B to person C. So if he is person B who receives it from person A, he doesn't necessarily have to have viewed it to have then, if he decides he wants to transfer it to person C, the exploitation of children, that crime continues regardless of whether he's viewed it or not.
I understand Your Honor's point, but I still think that this requirement, which specifically states that he has to also know that the material contained inappropriate images or videos of a person under the appropriate age, means that it must be proven that he viewed it, or that somehow he had knowledge of what it was, other than a vague file name, which is what we have here. So I think because I've thought of that, that very situation, what Your Honor is presenting, and I can't contemplate a solution to that, frankly, other than to say that it's the state's burden, unfortunately, for the state in this case, and they're required to show that he knew what the material was. So I don't understand how they can possibly do that if they're openly conceding that he didn't see it, or they can't prove that he saw it.
Well, how would you deal with the apparent? I don't think there was direct evidence that he knew, since he didn't admit. There is on count 2, correct?
Yes, Your Honor.
Okay. But then the other 2 counts, the titles, I think the thing that the prosecution would dwell on is the titles both had the PTHC in them. And they put that together with his search requests, and argue to the jury that they had, sufficient circumstantial evidence. How do we get around that? The jury decision on that.
I don't know that it is, because I don't think they had sufficient circumstantial evidence. I think they're just, and they concede that. They concede in closing argument and during the testimony at trial that we don't know that he actually saw this. We can't prove that he did, but he may have. And I would submit to this court that he may have doesn't satisfy the burden.
But you're going back to a supposition that he had to have seen it. If he reasonably should have known that it contained prohibited material, isn't that sufficient under the statute?
Except factually in this case, I think that I don't know how the state can prove beyond a reasonable doubt that he reasonably should have known, given the nature of the state's defense was that he mistakenly downloaded these items, if I'm not sure if the courts had the ability to read through the entire transcript. It's voluminous, but that the one count 2 item that Your Honor mentioned was where the defendant said it would be, which was in his recycle bin, indicative of the fact that he didn't like what he saw. He wasn't intending to get that, and that that's where it was located because he deleted it, or he thought he deleted it permanently. The other 2 items were found in a shared folder from the peer-to-peer network, and with no indication that he actually opened them. So I don't think that we even get to the point where the state's offering sufficient circumstantial evidence to rebut the hypothesis of the defense that Mr. Kadlecz may have accidentally downloaded these things, regardless of the file name. Your Honor mentions this acronym, which is common to folks, I guess, in the world of child pornography, but I would venture to say that most people wouldn't understand what that acronym means, and there was no indication that, or the state never proved that Mr. Kadlecz would have known what that acronym means. So leaving out that acronym from the file name, what you have left is just a vague sounding file name with no way to show that that definitely must contain the illicit nature which is prohibited by the statute.
Well, you have the one title from count 2, which clearly conveys child pornography, which he viewed. and then you have the search terms. And then I guess you don't have any direct evidence that he knew what PTHC meant.
That's correct, Your Honor. And that's really the crux of the argument here, is that my argument really is that even if you had a specific file name that was indicative of the nature and descriptive of the nature of the file, that even that on the internet isn't beyond a reasonable doubt proof that a person would know what that file is, because these files, and if you look through the names of many other files that were admitted into evidence, which are subject of other parts of the brief, you'll see that they contain various descriptions that seem different from the one description. So this is a long file name without any indication of what exactly the file is. Some of it describes stuff that would be inappropriate and some not. It would describe stuff that's just adult nature but not inappropriate, and they're combining these names into these files. So I would also argue that you can't prove beyond a reasonable doubt that someone knew the illicit nature of the file even by the name. But with regard to the names for count 1 and 3, if you take away the PTCH or PTHC rather, then you're just left with a vague file name, and so the state's relying on the assumption that Mr. Kadlecz knew what that even meant to prove its whole case on counts 1 and 3.
Could you touch upon the argument you made on, I think it's third issue, about the additional downloads and the prejudice that may have had?
Oh, I think, well, that issue was with regard to the multitude of file names that were admitted into evidence under the argument, which we would concede is incorrect, that the defense opened the door with their defense witness. The defense witness was called to talk about a variety of things, mostly what the defendant searched for, essentially. But the state argued successfully at trial that that opened the door for the state to basically discuss anything found on the defendant's computer. And I think that was an overstep. That was overreaching by the court.
What about I think Judge DeMortian was asking about the inextricably intertwined, the two.
That would be issue
two titles.
2, Your Honor. And I think that that's a mistake as well. I think that it justifies admitting it to evidence files that were not found on the defendant's computer because somehow they're inextricably intertwined. And I mean, I think that just a common sense argument about what that means, I don't think that one could find that it was in this case. It was separate file names. There's nothing prohibiting the state from entering evidence of the ones that were charged and excluding the other two. So the court's allowing that under the rationalization that they're inextricably intertwined, and I don't believe in any way, shape, or form there were. I mean, you could easily have tried this case without admission of those, and the state's case wouldn't have lost anything or wouldn't have been confusing to the jury or anything of that nature. So I don't think that inextricably intertwined measures up to what they were talking about in this case, and that would have been issue 2.
Let's say hypothetically that the judge erred in describing the reason for admission of that evidence as inextricably intertwined, and that it was more properly admitted as Williams rule evidence to prove knowledge, intent, absence of mistake or accident, had the state properly given notice of Williams rule evidence. Here there was a hearing apparently that occurred about a week before trial where this discussion came up pre-trial, perhaps not with the formalities of a Williams rule notice, but at least put the defense certainly on notice that this issue was coming because they raised it again just before opening statements occurred. So why wouldn't it be harmless error to have admitted that evidence? Because ultimately, if the state had done it properly as Williams rule evidence.
Well, I think the biggest reason, the rationalization why it wouldn't be harmless, and the state, they did flesh out this discussion on the morning of trial on whether or not the state intended to seek this as Williams rule evidence, and the state acknowledged that it wasn't and hadn't filed a notice. But I think the biggest justification that it wouldn't be harmless is that these are something, with regard to what I was just speaking about before, these are just file names. There's no indication of what these files were. That's the prejudicial value of these is just horrendous compared to the probative value, given the fact that you can't actually show what these files were. In other words, they're searching through a computer, finding a multitude of file names that have descriptions of an illicit nature, and yet no files to show exactly what the files were. So I think that's the biggest reason why it would not be harmless error. With that, I think my time's about to expire.
I'll give you a
here.
minute of rebuttal.
Okay.
Thank you.
May I please the court? My name is Janine Jamanowicz. I'm here today to represent the state of Florida in this matter. Of course, it's the state's position that there's no reversible error occurred in this case, and the defendant's convictions and sentence should be affirmed. With regard to point one, which is the JOA issue, we're talking about the statute, which really requires only possession. Of course, it doesn't require that he actually have viewed. I think one of the judges had made the point that, somebody that had just merely possessed it with perhaps the intent not to view it, but to pass it on to a third person via the area shared by a program, that would also be possession of child pornography, and so that would qualify as well.
What if the name didn't indicate the content of the of what's in the download? So a person downloads what appears to be an innocuous video and doesn't look at it, but it's in their computer. You've got an undercover detective going through the process, locates this particular file in the defendant's computer. Would the defendant be subject to prosecution under this statute, having never looked at it? And there's no indication in the title that it's connected to child pornography. But in fact, it is child pornography on the video. Under the state's, is it the state's position that person could still be prosecuted?
I would think so, yeah, in terms of if just the statute just prohibits child possession of child pornography, of course, if you view something that implies that you have possessed it in order to view it, so, that's like a second issue. But the fact of the matter is the statute just prohibits possession, and that's enough. Now, in terms of actual knowledge of what was in the files, and in terms of intent, there's a number of pieces of evidence that point toward that direction. First of all, the defendant is a sophisticated computer user. He admits that he downloaded everything, including porn, from Aries, and that he is actually a sophisticated porn user because he has downloaded thousands of porn files, and that he admits that at least some percentage of those porn files were child pornography files, and that it's certainly quite inferable that somebody who has downloaded thousands of porn files would certainly know that PTHC stands for pretrial hardcore, and that that's something that was in the file name. But there's another thing in terms of the file name. If you look at count 3, which has to do with count 3 is Masha Day 7, open here, new here, finger. If you look at the title itself, it suggests that also of child pornography, not apart from the PTHC, so that's another indication that he knew that there was child pornography involved. And then in terms of the downloads, he is actually downloading them in batches, and he is downloading, like with regard to the dad coming and tablet video, he is downloading 7 files on one day. And of those 7 files, 5 of them, including the dad coming and tablet video, all relate to child pornography.
On that one tape or video, other than the PTHC, how would he know? How would a reasonable person know that was child pornography from the title? Are you saying that King Pass or Lilu Planet are code words for something?
No, I'm not saying that, but what I am saying is that somebody who is two things. First of all, I'm saying with regard to count 3, and I don't mean to get indelicate here, but with regard to count 3, the suggestion that we have new hair, open pussy, it is suggested that somebody is actually looking at a young child's first prepubescent hair growth. And so that's what I'm getting at with regard to count 3. Now, in terms of the other evidence, I'm suggesting that somebody who is a sophisticated porn user and a sophisticated computer user is certainly going to know what PTHC means, and that he is sophisticated enough to know that Erie keeps a list of all of the search terms that he uses. He avoids searching for PTHC, but he certainly searches for any other number of child pornography terms, such as, young budding breast or, young pussy and stuff like that. And when you look at the totality of the evidence, you just get the abiding sense that he knew exactly what he was doing. And so that's what the state is getting at with regard to that. In terms of consciousness of guilt, he's trying to minimize by telling the police officers that he had watched the dad coming on tablet video 2 years ago, when in fact it was right there in his shared file only in August, the month before the computer was seized. And then the fact that the police found a CCC cleaner-like program, which is a program that removes evidence from your computer, basically, whether it be for innocuous or not innocuous reason, but, all of the circumstantial evidence that to show that the registry or cleaning program had been used recently. And again, he was a sophisticated computer user, and the fact that there was evidence that he had watched the dad coming and tablet video, and that once he watched it, he deleted it, but the other 2 were still in his shared Aries file a month later. Certainly suggested that he's saving them for later viewing. Again, when you look at all of the totality of the evidence, we're submitting that, yes, he absolutely knew what he had in his possession.
So if I understand the state's position correctly, going back to Judge DeMorgian's question earlier, if you have someone who never has searched for child pornography or any pornography, but one day happens to see something on their computer, they go to click on it, and inadvertently they click on the link to these 2 files, which comprise counts 1 and 3, that person is as equally susceptible of being prosecuted for this charge as a person such as this defendant, who allegedly has been searching for child pornography, general pornography, for an extended period of time and has a lengthy computer history and expertise. Those 2 people are both equally susceptible of being prosecuted. What ultimately happens, the difference is the former person, because of their lack of evidence, may be acquitted if they're lucky, but the latter person is likely to be convicted because of the overwhelming totality of evidence. Is that the state's position?
Yeah, exactly. I mean, I'm not denying that, perhaps it's possible to accidentally download something and then realize, oh my gosh, it's terrible, I've downloaded something awful and I deleted it immediately. That's possible, certainly. But in the case, that's not what you have. You have this huge history of all of the stuff that he's searching for, and it's just not that case. With regard to, would you like me to continue with point 1, or would you like me to pass on to point 2 and point 3?
It seems most of his search terms use the word young. Is there a sort of, is the state asking for sort of an implicit, I guess, finding that the search term young means search for child pornography? Because, I guess 18 in some minds could be young. You seem to be putting a lot of reliance on the fact that he used the search term young, and that the titles came out PTHC, but he's claiming he didn't know what PTHC meant, and young seems to be somewhat ambiguous.
Okay, I did spend a lot of time listing all of the evidence that was found on the defendant's hard drive, and I'm just going to give you a couple of examples. Young girl, chest birth, pretty young little titties, very young teeth, young developing breast pictures, young girl, chest birth, and young puppy nipple. So when you're getting down to that nitty gritty, you can see the search terms are definitely geared toward finding child pornography. And also, if you look at the other files that were, file titles that were found on a computer, you see stuff like 12-year-old boys and girls playing ethics, and then other things like that. Young tight vagina, youngest cunt pictures, and young breast development pictures. So when you're looking at the totality of the evidence, that's where you're getting the abiding conviction that, yeah, he's looking for child pornography. I mean, it's not just one term here and there. I mean, there's like a slant toward the very, very youngest victim, and not just people who are 18, for example.
Okay.
Okay. And with regard to that, I'm trying to think of this.
The two titles that were didn't have the files in it that the state argued were inextricably intertwined. Were they also used for impeachment? Did the state argue that they wanted to be admitted for impeachment purposes?
Are we talking about point 2 or point 3?
No, not 1, 2, or 3 of the other two.
You're talking about the 2 of the 5 videos that were, you're asking if they were introduced as, they could have been introduced as impeachment evidence actually, and that one of the state's arguments would be that it's harmless because it would have come in on rebuttal even if it didn't come in on the state case in chief. I don't know if that quite captures the answer to your question.
Well, I was asking if that's the state's position, that they were also introduced for impeachment. Were they also introduced for impeachment, or just for the inextricably intertwined?
No, they were introduced for everything. I mean, they were introduced for knowledge. They were introduced for the fact that they were inextricably intertwined, and the fact that it was necessary to admit all evidence of all of the files to adequately describe the deed, everything. So, including impeachment, yeah. So ultimately, it would have come in on impeachment and rebuttal, even if it had not come in on the case in chief.
Okay.
Okay. In terms of the other two issues, with regard to point 2, which is what we were just talking about, I'd just like to point out that in terms of the harmless error argument, even if you don't accept that the trial court properly admitted these 2 titles in the state case in chief, first of all, you got to find out that the trial court and everybody made it very, very clear to the jury that no videos were found that were associated with the title, that the judge gave a curative instruction to the jury regarding this evidence of other crimes, and that the question of how his defense would have been any different whatsoever, because his defense is that, oh, he accidentally downloaded the file during a book download. So how is his defense any different from, oh, I accidentally downloaded these 3 files during a book download versus I accidentally downloaded these 5 files during a book download, when we're talking about somebody who downloads thousands of porn files, in terms of that, there's really no harm to the defendant in terms of his defense. And then again, as I said, it would have come out during rebuttal, if not during direct. in terms of point 3, which is the other, which you can't, I'm sorry, I think I'm running out of time. Is there any other question that you would like me to address, or, okay, I think I'm just gonna rely on the state's brief and urge the court to affirm the defendant's convictions and sentences. Thank you very much.
Thank you. I'll give you a minute, counsel. Thank you.
I think the biggest point that I'd like to address is that the point that the state made regarding the thousands of files that this gentleman had downloaded over a given period of time, and that would make him have more of a knowledge of how things work. I think it cuts the other way, actually, the fact that he downloads thousands of videos, most of which are legitimate legal videos that are allowable, and the fact that the ones included in this trial, including the ones he was charged with and the ones that the state, we are arguing, were allowed to admit and shouldn't have been, those things could get caught up in this net results of a person who's searching for thousands of things and has been doing so over time. With regard to the search results or the actual search terms used, I think that there's a whole genre of pornography involving young people, teens, legal age teens, that may even be considered the most popular among people who look for that sort of thing. And what is young to a 69-year-old man, Mr. Kadlecz, might not be young to somebody else. So I think that's all relative. His search terms indicate that he may not have just been looking for illegal things, he's just looking for legitimate pornography that he would be allowed to view.
Thank you, counsel. Thank you. Our next case is Greenspoon versus State.